Ladies and gentlemen, we have a lot to deal with today, so perhaps we should get started. My name is John Clayton. I work with the CLE department at the Law Society, and on behalf of the Law Society and the Canadian Bar Association Ontario, I'd like to welcome you to this program and to introduce the first speaker, Senior Judge Lucien Beaulieu of the Toronto Family Court. Judge Beaulieu has been a provincial court judge since 1973. Apart from his involvement on the bench, he's had extensive experience with youth issues. He has a Master of Social Work degree, was chairman of the Ontario Task Force on Vandalism, is currently vice president of the International Association of Youth Magistrates, and is also involved with a number of other organizations concerned with youth problems. He's been a guest lecturer at the University of Toronto, at Queen's University, and at a number of other institutions, and has appeared regularly in the media speaking about juvenile issues. I'd also like to mention that Judge Beaulieu has played a major role in the planning of this program. In fact, he's been involved in the planning of this program for at least 2 years now, waiting for the moment. The moment has now come, and he's here, although he tells me that he was up until 3:30 in the morning writing a judgment. I guess that's the way it goes. He's bright and ready to go right now. Judge Beaulieu.
Thank you very much, John, and welcome, ladies and gentlemen. I don't know how bright I am, but I think we're ready to go. I see many familiar faces in the group this morning from as far away as the metropolis of Timmins and Peterborough and Cambridge. I think it attests to the interest that has developed in this subject. I also note that as a result of many of the questions that were being asked earlier and the time that is spent on coffee, that I now have exhausted 5 minutes extra than what was allotted to me for the remarks that I have this morning. I do not intend to keep the tardiness that unfortunately has developed and pass it on through the whole day, so therefore I will skip over most of my prepared comments and try to get to the panels, that is the practical experts, as soon as we possibly can. All of you are now familiar with the fact that the Young Offenders Act was passed on April the 2nd. It now represents some 52 days of new legislation and what some of us had grown to call an era of really basically a new ball game with new rules, new offenders, new offenses, and new officials. It appears that we have, to a certain extent at least, arrived at a conclusion to our collective search for an effective legislative response to the, quotes, problem of youthful offenders in this country. It is no secret to anyone that the collective search for that legislative response has been going on for literally over 2 decades now. I propose to you that the examination of this response, the Young Offenders Act, must at all costs be seen in the perspective and with an eye to the historical development of the juvenile court system. I emphasize again that this is a new ball game, and in order to be able to understand how new it is, I think it's important that we look at and appreciate where we come from in terms of juvenile justice and juvenile legislation in particular. The Young Offenders Act and the principles upon which it is based are dramatically different from those that were found in the Juvenile Delinquents Act. And I personally have found it very helpful, in order to understand some of this, to borrow what I call the analytical approach of a man by the name of Charles Reasons. I hasten to add, for those academics among you, that is about the extent of my affinity with Mr. Reason's philosophy. But nonetheless, his analytical approach to me is quite relevant in this set of circumstances. He says that any legislation has both an expressive character and an instrumental character. By the expressive character, he means the values which are defended by the legislation. By the instrumental character is meant the degree to which the values are effectively prosecuted or sanctioned. And I think if we examine the Juvenile Delinquents Act with its essential basis on the philosophy of apparens patriae, we can see that that legislation's expressive character was clearly focused on values such as protection, guidance, education, supervision, and treatment of, quotes, misguided youth. There was virtually no distinction between neglected and delinquent children, for example. The focus was primarily on treatment with minimum attention to the idea of accountability. There is a blurring of the concept of neglect and the acts of a criminal nature. The Young Offenders Act has, to a great extent, changed that focus. The expressive character of the Young Offenders Act is based primarily on the idea that youths who are alleged to have committed offenses will be accountable and responsible for those acts. And in addition to that, there's a balancing of the protection of the community interests. The Young Offenders Act does, as the Juvenile Delinquents Act had, have a mixture of criminal law and some protection philosophy. However, the scales are weighted in the Young Offenders Act, at least at the pre-adjudicative stage, on the criminal law. And the paternalistic character of the Juvenile Delinquents Act, if it does come in, is basically geared to the dispositional stage. We see, therefore, a focus on criminal activities as distinguished from neglect and protection. The Young Offenders Act states very clearly that we are not dealing here with a grab bag of conduct which is not recognized as criminal for an adult, but would, under the Juvenile Delinquents Act, have constituted a delinquency and also invited consequences of a record for that juvenile. And those of you who worked in there also know that that included not only truancy, but sexual immorality. And as Cousino from Timmins would say, not sexual immortality, but immorality. The Act, Young Offenders Act, introduces duties directly or indirectly on virtually everyone dealing with a young person. That includes peace officers, prosecutors, the youth courts, counsel, provincial directors, and so on. The Act proposes or has proposed codification and extended case law in a number of areas of the law. For example, the admissibility of statements of young persons, notice to parents, transfer hearings to ordinary court, requirements of predisposition reports, and many of the types of dispositions incorporated in the ratio of previously decided cases are now incorporated into some of the principles of law that we see in the Young Offenders Act. The important concepts of the right to counsel, public hearings, expanded appeal provisions, determinate custodial dispositions in specific places of open or secure custody, court-ordered assessments, recognition of victims and the community in the type of dispositions. The bail provisions of the criminal code are made applicable. There's a definition of records, the use to which these records may be put, mandatory destruction of records required by the Act also. Review provisions seem to be suggested that that they will function essentially as a kind of a mini parole system. The Act, therefore, is really attempting to move us into a new area with respect to juvenile and youth offenses. The panels, the quotes experts that we have been able to get for you today will be dealing with some of those practical measures. As I said at the outset, that the expressive characters of the Young Offenders Act, that is, the values which are intended to be defended, seem to be relatively clear. However, after a few days of practice, they may not be quite as clear as we thought they were. Those matters will be discussed. The instrumental character of the Young Offenders Act, that is, the manner in which those values will be enforced, sanctioned, protected, in many respects remain to be seen. And that, again, you will hear from those practitioners who will be involved. The significant thing to remember about the effectiveness of the development of the instrumental character of the Young Offenders Act is that it will, in my view, depend essentially on the degree to which we, all of us, individually and collectively, try to come to grips with the expressive character and then collaborate in effecting the instrumental character, because the instrumental character will be shaped by you and by me and all of the other members of the community dealing with the legislation. Whether or not it actually takes shape in the manner in which is expressed in the Act in 15, 20, or 35 years will really depend on what it is that we do in the next few weeks. Toward that end, I sincerely hope and trust that the sessions today will be of some beginning help to you, and I'm sure that the experts, as I said, that we have called upon can lead you that way. In that vein, let me at this stage introduce to you the chairman of the first panel, His Honor Judge George Thomson, who is probably known to the vast majority of you as a judge who was born, raised, and has been extremely active in the general area of law, not only in his native city of Kingston, Ontario, but as well in London, Ontario, where he received his Bachelor of Arts degree in 1962, a law degree in 1965, and then came to article in good old friendly Hogtown, Toronto. In 1968, he attended the University of California in Berkeley. It's for those of you who do not know George, after having done his Master of Laws degree on labor disputes, he came back to Toronto, or Kingston, sorry, and quickly became known as the Flying Judge on motorcycles, hair and gown flying in the back. The subsequent to having established a tremendous amount of community support with the family court in Kingston, he was appointed in 1977 as Associate Deputy Minister for the Provincial Ministry of Community and Social Services, and was in that position up until 1982, and just recently has, fortunately for us, decided to come back to the bench and is presently employed, giving us all of the benefit of his policy writings and decisions while in government at 311 Jarvis Street and the courts in the Judicial District of York. I introduce, therefore, to you His Honor Judge Thomson, who will introduce his panel. Thank you. Oops.
Can we take this down?
Yes.
Thank you. you maybe come this side? John, you want to sit here?
Leave to give you a mic. Well, thank you very much, Your Honor, and I'm pleased to be part of today's proceedings. My task is a very simple one of simply chairing the panel discussion that will now take place and introducing the experts who will be presenting to you. Our topic in our session at this point is arrest, bail, notice, and age from three perspectives, as you will see in the program. And we do have three perspectives represented on this morning's panel: a Crown Attorney, a counsel from the Ministry with responsibility for police services, and a member of the Defense Bar. We decided, given the number of issues to be addressed in this panel, that rather than asking each of our experts to address all of the issues from his perspective, we would rather separate them out, divide them up. You'll hear from each one of them on a specific issue or issues, and then we'll allow some time for them to comment on, disagree, violently oppose, whatever the positions that the others have taken, and then leave some time for questions if that time's available. And we hope we have identified most of the issues that we think that you would be interested in hearing discussed this morning as you prepare for or continue to live with and apply the new act. What I'll do at this point is introduce all three panelists rather than doing it one at a time. On my far right is John Chalmers, who's counsel with the Ministry of the Solicitor General. Although relatively recently called to the bar, he's eminently suited to present to you this morning from a police perspective, because prior to attending law school, he was for 16 years a member of the Ontario Provincial Police. He's married with 2 children. He has been a lecturer and continues to be a lecturer and an author on police matters, as well as more recently materials and issues relating to the Young Offenders Act and the new Charter of Rights. And he will deal with the issue of arrest. Beside him is Mr. Stanley Avruskin, who is a lawyer here in Toronto, who specializes as defense counsel in criminal matters, what were called juvenile matters under the Juvenile Delinquents Act, now YOA cases, and he's already building up a list of cases that he's involved in under the YOA, and a number of child protection cases as well. He's not just known as a world traveler and wearer of impressive hats, but also as an active and diligent lawyer who leaves no stone unturned in his effort to find defenses on behalf of his clients. He was educated at the University of Toronto, Osgoode Hall Law School, and in England, called in 1963. He's had a varied career as a judge advocate, a student of air law. He was involved as a specialist in civil litigation from 1966 to 69, and since then has carried on his own practice as primarily defense counsel. And then to my left is Mr. Brian McIntyre, QC, who's a Crown Attorney in Essex County, specifically Windsor. Before that, he was executive counsel to the Deputy Attorney General here in Toronto, and before that, an assistant Crown Attorney here in Toronto, and has a very well-known reputation that goes well beyond Essex County as a Crown Attorney and a specialist in criminal matters. He was educated at the University of Toronto and Osgoode Hall Law School, and he is married with 2 children. Well, now with that overview, we'll now move straight into the issues to be addressed, and I'll call first on John Chalmers to talk to you about the issue of arrest. John.
Thank you very much, Your Honor. Ladies and gentlemen, it's my distinct pleasure to be here to deal with the subject of arrest for you. As I look about the audience, I recognize many faces. For those of you who are not aware, if there is a problem here today, sprinkled throughout the audience, I do have undercover police officers. They are not here to learn anything. They're here for my benefit and my protection. Dealing with the subject of arrest, I suppose the first thing that one should do is dispel the immediate myth that every time someone becomes involved with a police officer, whether he commits an offense or is suspected of it, is that there's an automatic arrest. There is not, never has been, and I don't expect with the new Young Offenders Act that there ever will be. There are, excuse me, some basic changes in philosophy, as His Honor Judge Beaulieu pointed out to you, with regard to the Young Offenders Act as compared to the old Juvenile Delinquent Act. The first thing that I think everyone should become familiar with and aware of are the definitions under the Young Offenders Act. For purposes of arrest, the most important definition under Section 2 is the definition of offense. No longer, as Judge Beaulieu pointed out, will we be concerned with sexual immorality or status offenses, committed against provincial statutes, municipal bylaws, or regulations. All powers of arrest that relate to what anyone, whether it be a private citizen or a police officer, can do will be covered by the relevant sections of the Criminal Code and the provincial statutes that supply powers of arrest. By virtue of Section 51 and 52 of the Young Offenders Act, the provisions of the Criminal Code of Canada, so far as indictable offenses and summary offenses, the distinction between the two, and the powers that prevail are carried on, and you must turn to Section 449 of the Criminal Code to find out what the particular powers of arrest are. Under Section 449, and now we're dealing about everyone, not just police officers, but everyone, including property owners, private citizens, the store owners who are traditionally those involved in arrests, particularly with young people who commit the offenses of shoplifting and loitering and trespassing. Under the Juvenile Delinquents Act, of course, there was only one offense per se, and that was that you committed a delinquency, no matter what it was. And the subject of arrest has always been a little hazy at that particular stage. I suppose mainly because young people under the age of 16, between the ages of 7 and 16, really didn't have any rights as we know them under the Young Offenders Act or under the Constitution. The only right that a young person had was to do what he was told and go where you will. People didn't look upon taking a young person into custody as an arrest, mainly because he was doing it for the protection of the young person in his better interest. It was not generally thought to be in the interest of society. A young person was taken to an observation detention home, taken into a police station, returned to their parents, all under the guise of this is for your own good, for your welfare, your benefit. Parents patriae was not such an ignominious statement. That's the way everybody dealt with it. You were the all-seeing parent, and as we all know, parents don't give their children any rights. The only right they have is to do what they're told. That has now changed, as parents will be surprised to learn the first time they're faced with a legal bill, which I'm sure comes as a great benefit to many people here in the audience. But for the particular part of the arrest, anyone may arrest either an adult or a young person found committing an indictable offense, or if they have reasonable and probable grounds to believe that that young person or adult has committed a criminal offense and is being freshly pursued by someone with the authority to arrest them. A property owner may arrest a young person found committing a criminal offense on or in relation to his property. Now, in both of those particular situations, anyone other than a peace officer who effects an arrest must turn the young person over to a peace officer forthwith. Now, the police officers peace officer as defined in the criminal code obviously have broader powers of arrest than the average citizen. Not necessarily because they're smarter, it's just because they know more. A peace officer may arrest without warrant anyone who has committed an indictable offense, or anyone who on reasonable and probable ground they believe has committed an indictable offense, or anyone who on reasonable and probable grounds they believe is about to commit an indictable offense, or anyone they find committing a criminal offense, which includes summary conviction. For those particular reasons, I think that you will agree the distinction that is raised in the criminal code, Part 14, for the powers of arrest and the distinction between summary conviction offenses and indictable offenses is important. Now, I won't get into what happens following the arrest in particular, because that's Brian McIntyre's area, but I think that to date, and from the police departments that I have dealt with and those that I have talked to, it is not expected that there will be any, at least until April of 1985, when we start dealing with a larger group of people, when the 16 and 17-year-olds are brought into this category. It is not expected that the number of arrests will change in any fashion whatsoever. Manpower dictates, for one thing, lead us to the conclusion that the police officers, the police forces generally, if it's unnecessary to arrest, they won't effect arrest, because given the procedures that you have to follow once you do make an arrest, you'll spend half your time, and half your youth bureaus will spend most of their time babysitting young people until they can get them in front of a justice to deal with a certain release. It's much easier to release them with an appearance notice or on a promise to appear and have them appear in court. This is provided for in Section 450, subsection 2 of the Criminal Code, that is worded in the negative, talking about a peace officer shall not arrest a person without warrant. And then it lists a number of situations where he cannot arrest. Most of them deal with summary conviction or dual procedure offenses, the hybrid offenses, indictable summary, or purely summary conviction offenses where the public interest has been met without benefit of an arrest, such as establishing the identity of the person, or securing or preserving evidence, preventing the continuation of the offense, or whether or not you have reasonable grounds to believe that he's not going to appear in court. And that will be covered in more detail by Mr. McIntyre. Now, the areas where arrest is really affected is the areas that were known to be delinquencies, and by virtue of Section 2, which defines offense in the Young Offenders Act, will no longer be offenses under the Young Offenders Act. That is all provincial statutes and all municipal bylaws, offenses which traditionally were part of the things where a police officer, as an example, you would find a young person riding a bicycle on the sidewalk or knocking down old ladies or what have you. They could take the young person into custody long enough to at least take them home or to the police station, have the parents come and get them. Well, that in effect is an arrest, and there is no arrest power for that particular procedure under the Young Offenders Act. The provincial statutes, provincial offenses, provides for a very limited power of arrest. All provincial statutes, all arrest powers under provincial statutes are found in the creating statute. If you can arrest for a traffic offense, then you have to find the power of arrest under the Highway Traffic Act. If it's under the Trespass to Property Act, then you have to look there. There have been amendments. Bill 140 is, and I understand that will be explained in greater detail later today. Bill 140 deals with the amendments under the provincial offenses statutes that affect young people, that have defined a young person for purposes of provincial statutes as someone between the ages of 12 and 15 years. There will be no change for 16 and 17-year-olds so far as provincial statutes are concerned. The major change will deal with those between the ages of 12 and 15. And the normal powers of arrest that you find for someone committing an offense such as trespass to property under the provincial statutes will no longer be applicable. The provincial procedures will provide that you may only arrest if there is some danger to be shown to the person or serious danger to a person or property, making it necessary to effect an arrest. So the ordinary provincial offense statute will be dealt with by summons. The other area that has caused some concern is the amendment to the criminal code by virtue of the Young Offenders Act, which changed the age of responsibility from 7 to 12. Now, a person who commits an offense and is under the age of 12 at the time will not be subject to any kind of criminal proceedings or provincial proceedings under these statutes. It would appear that the major area that is left to deal with these people will be child welfare legislation. Now, that is going to cause some concern to people who are involved with 9, 10, 11-year-old people, kids who go in, they're stealing chocolate bars, candy, not anything that seems to be earth-shaking or shattering, and no particular reason to lock them up in jail, but the problem is how do you deal with them? Where do you take them? What do you do with them? There is an amendment to the child welfare legislation that's before the House now. I'm not sure how long it will be before it's passed, and it will also be part of the new Family Services Act when it comes into being, giving a police officer the authority to detain a person in that situation, a young person under the age of 12 who has committed what would otherwise be an offense, for the purposes of either taking him home to his parents or holding him long enough to ascertain whether or not he is a child in need of protection pursuant to the child welfare legislation, and then turning him over to the appropriate authority. Now, the one area that I would briefly like to touch on, that following an arrest, assuming that a young person is arrested, he is not released on an appearance notice, he is not released on a promise to appear, and he's going to be detained pending a bail hearing or an application for judicial release, then the Ministry of Community and Social Services have designated a number of facilities known as observation and detention homes where the young people will be taken to. The one immediate practical problem that has arisen is that, unlike under the Juvenile Delinquents Act, where a police officer who effected an arrest at 2 or 3 o'clock in the morning could take someone directly to the observation and detention home pending an appearance before a JP, will no longer be able to do that. The observation and detention homes have been advised by that ministry that they must not accept anyone without a proper remand warrant, which in effect means that until such time as an appearance can be made before a justice of the peace or a youth court judge, then that young person who is being detained will be detained in police custody in a police cell. Those are the comments and the remarks that I wish to make with regard to arrest, subject to any questions that may arise later. Thank you.
Thank you very much. I might just add two things. One is that Child and Family Services Act that was referred to by John is a bill that has just been introduced for first reading before the legislature, I think last Friday. It contains 2 new definitions of child in need of protection under the child welfare, the child protection part, which refer to children who commit or engage in behavior which would is either very serious behavior, like killing someone or serious damage to property, or a pattern of less serious behavior that the parents have not responded to or been able to provide supervision or prevention, be able to prevent or seek appropriate help to prevent, that becomes in itself a definition of child in need of protection. It does raise some interesting questions about the child who comes before the court under a child welfare proceeding who says, I didn't do it. Does one have a mini trial within a child protection proceeding? But that bill is presently before the Act for first read, for the legislature. It's had first reading, and where it goes at this point, as John says, is uncertain. Secondly, you may want to know that there are conflicting decisions at the moment as to whether or not truancy remains as an offense, at least truancy charges laid prior to the YOA coming into effect. There is a decision from Judge Felstener saying, yes, it's still available, and all the dispositions under the JDA are still available for truancy charges laid prior to April 1st because the Education Act incorporates the Juvenile Delinquents Act, even though it's now been repealed. There's a decision of Judge Caney recently saying the opposite. And there's no decision yet as to whether or not such charges are available other than as provincial offenses in the new provincial offenses legislation for truancy that occurs after April the 1st. And that's the status of that at this point. We won't deal with questions at this point. We'll wait till we've covered all three areas. And Brian McIntyre now will deal with judicial interim release.
Thank you very much, Your Honor. First of all, I think it's important for all of us as lawyers to welcome this legislation, as it really is much more a lawyer's act than the JDA was. It's an act that's full of flaws, which I'm sure Stan will like, but it's basically a codification of everything that you need to know for the purpose of doing a case in the youth court. And anything that's not in there does not exist, unlike the Juvenile Delinquents Act, where there was flexibility and there were practices that seemed to be outside the legislation. I think now you can look to this act and it will take you right into the criminal code, which I hope and I trust we're all familiar with, and will be easy territory for us to make a link between a juvenile and an adult offender for the purposes of procedure. So I would think that from the point of view of a practitioner going into the youth court, it'll be a much easier act to deal with. And I welcome it in that way. It's no longer a social work type of legislation, which I think we've been laboring under for many years. Now, as far as the procedure is concerned, I've got the fairly easy area, but I think it's crucial to read over sections 52, the provisions of 52 very carefully, and think about what it means in terms of this overall legislation. If you have it available, this is where it makes it easier for us, given our familiarity with the criminal code, because it very specifically brings into procedural existence the totality of the process under the summary conviction part of the criminal code. So whenever you have any doubts about any procedure, you can turn to your knowledge of and your awareness of criminal code summary procedure for all of the trial processes, whether it has to do with adjournments, whether it has to do with subpoenas, whether it has to do with any evidentiary issues that may come up. You're dealing with it as a summary conviction trial, regardless of whether the offense is indictable or not. So I think that's crucial to understand about this legislation. And again, it brings in the totality of the code in subsection B, in so much as it relates to trial procedure for summary offenses, which again incorporates all of the sections in the code that are incorporated by the summary conviction part of the criminal code procedurally. So I think it makes it quite easy for us to, in terms of procedure, to not have to fantasize about flexibility and statutory interpretation that doesn't exist under the JDA. We've got a very clear code of procedure. Having gone through that, it is important to bear in mind that the indictable summary distinction remains, and it remains specifically under 52C and D, And the summaries, of course, remain summary, but the indictables are indictable for all purposes except they're tried procedurally as summary offenses. And that's essentially what the Act is saying in Section 52. A break and enter is an indictable offense as a juvenile commits it, and if he is convicted of it, he is liable to punishment as an indictable offense under the Young Offenders Act. However, the procedure that applies to the whole case in court is a summary conviction procedure. And for trial purposes, I think that's important to bear in mind. So once you've gotten over that hurdle, I think that when you go through the Act, there are very few changes in procedure. As you will note at the beginning of 52, it says except insofar as they are not inconsistent with this Act. So all your summary provisions for any summary trial apply except where they are inconsistent. Now, there are some major areas where they are inconsistent, and I'm only dealing at this time with those few, I trust, young offenders who are placed in custody by the police. And based on what John has said and based on my experience so far, I think there will be very few. I think, as John says, the police are not anxious to place young persons in custody. They have to put them in a separate cell. They have to be very careful they don't get hurt or into trouble, because it would be most upsetting, no doubt, given the obligations under this Act to notify their parents, to place them in a separate cell. I think that the police are going to be very hesitant to arrest any juvenile or young person who has not committed a very serious offense. In other words, I think they're going to release them to their parents or to another responsible person. So I think when I deal with the bail aspect of it, we're dealing with the serious crimes, probably mainly the indictables, and hopefully very few of them. There are two sections in the YOA that have to be read in conjunction with the criminal code bail provisions, and they are sections 7 and 8. And if you can just turn in your materials to 7 first, and section 7. And bear in mind that these are the provisions that are in addition to your bail provisions for summary offenses under section 457 of the Criminal Code. So when you do have a juvenile or young person come to you as a client, your first reaction would be that it will be a bail hearing the same as an adult would be facing in similar circumstances as far as the procedure is concerned, subject to sections 7 and 8 of the YOA. Now, under 7, you have the dealing with a person who has been arrested and detained. So it's important to note that that is after a detention order and detained by the court, not detained by the police. Detained by the court prior to a disposition, in other words, prior to the final sentencing or disposition under the Act, that person must be placed in a place of temporary detention, which is designated by the Lieutenant Governor. And as John has said to you, those places are being designated on a list by the Lieutenant Governor in each community. A young person cannot go anywhere else. He cannot be held in the police slammer. He cannot be held in anywhere that has not been specifically designated by the court. And the reasons are obvious given the philosophy of the Act. They don't want young offenders mixing with adults or anyone else. So that is an inconsistency with the provisions of the bail in the Criminal Code, and therefore has to be read as a separate issue on bail. You go to subsection 2, and it's kind of an odd section because there's no definition of it. It indicates the place does not have to be designated for temporary restraint. And temporary restraint is not defined, and I will give you my prosecutorial interpretation of it, which some may disagree with. But what subsection 2 allows is upon arrest by a police officer on the street, after he has satisfied himself that this is a rare case where we cannot just let him go on an appearance notice or a summons or a release on the street, that person must be kept in temporary restraint in the hands of a peace officer after arrest prior to his detention. So I think it's important that this is before court. This is the only section that deals with the before court provision, allowing a policeman to detain him in somewhere other than a designated facility. And the need for that section is that if it wasn't there, the policeman would be committing a crime by putting him anywhere other than the designated facility, because it's an offense to put him anywhere else under this section, as we'll see in a moment. So essentially, when you read a section like that, you've got to immediately click in your thinking about the summary provisions of the criminal code. You go back to section 454, a justice of the peace has to have an accused brought before him within 24 hours. So you always click into the criminal code procedure. And as we all know, you've got 24 hours or as soon as practicable in advance of that to bring him in. So this section is only dealing with that brief period between arrest and appearance in court before a justice. And during that period of time, as John has pointed out, the youth will have to be held by the police in their jail, in their cells. And it's clear from the philosophy of this act that he cannot be held with other adults. The police are going to have a separate cell area. If you show up in a police station to see a young offender client and he's in the bullpen with 20 adults, you've got a fairly substantial basis for not only complaining, but perhaps charging the officer who has placed him there, if not other remedies that may be available to you about any evidence that may flow from that unlawful locking up under this act. So he can be detained for up to 24 hours under the provisions of 454 of the Criminal Code. He must not be put in one of these temporary detention homes designated by the Lieutenant Governor. They will not accept him. He'll have to be held in the police station. And I think that's basically good in policy in any event, because until a judge has dealt with the case, we don't know if the kid may be dangerous, may be violent, may be a danger to himself or others. So it's desirable he be held in that type of custody pending a judicial decision on his status. So as we go through it, after he is then brought before a justice, you will note in the next subsection that he cannot be detained in any part of a place where adults are held. So that's in simple form what is required by the YOA, which is of course inconsistent with the Criminal Code and therefore requiring a special section. And if you just slip down to the bottom of the section, you notice it's an offense, a summary conviction offense for a police officer to detain him in breach of that provision. So it's not only just bad practice or bad policy, it's a summary conviction offense for him to be locked up with the adults. And I would take that to mean that even if he's in a row of cells and next to him is an adult with just bars in between, I think you've got a pretty good argument that that's an unlawful incarceration under this act. I think he has to be held in a totally separate lockup facility without a communication between him and adult prisoners in order to comply with this section. Now, you will note that it deals with the issues of the safety of the young person and so forth. A judge can order him held in another facility, in other words, a jail, separate from adults, if he is a person who might be a danger to himself or a danger to others. And obviously, if you have someone charged with a mass murder or something like that, I would presume that section may be an appropriate way to deal with it rather than putting him in a detention home with a bunch of other young people who may have committed very minor offenses. But that's a determination for a youth court judge to make in court. There's a weird section in there, section 5. I don't know if anybody on the panel can help me with what that means, but it just doesn't mean anything to me. It talks about sometimes people can be designated to authorize detention before appearance in court. It doesn't say who these people are, it doesn't define them, and it doesn't say why they're necessary. So I'm ignoring it as though it doesn't exist. I think it's kind of a strange section. Maybe somebody has some ideas about why it's in there. But in any event, I think 7 is the part that you would have to know that would be inconsistent with the procedures under the criminal code for summary offenses. We then, and I'll try to be fairly brief, drop down to the actual court appearance. So we finished with 7. We are into court. We are going to have a hearing that would be consistent with any 457 hearing you've ever had before for any other offense. And you go to court on Section 8, and you start off with the presumption that a youth court judge should hear the bail application. And that's contained right at the beginning of the section, that it should be a youth court judge unless one is not reasonably available. And I think, again, the importance of that is that the philosophy of the legislation is to keep control of all young offenders within the youth court judge and not give it to a justice of the peace who may not have the training or the subtlety to do the right thing. And the problem with this section is that I am led to believe that youth court judges are going to declare themselves not reasonably available at any time after 4:30 or 5 o'clock in the afternoon, although they're highly paid for their job, which they do very well, of course. But in any event, they're also going to declare they're not available on Saturdays, Sundays, or holidays, which means that potentially there can be some languishing in prison by a young offender because of that, and an appearance before a justice of the peace. I am very, as a prosecutor, very concerned about that because of sub 2 of 8. And if you look at that, it says you can take them before a justice of the peace for a bail hearing where the judge isn't available. So if we have a Saturday, a Sunday, or a holiday, and the 24 hours is running out on our 454, and he's being detained beyond that, we've got to produce him in court. I'm going to make every effort in my jurisdiction, at least, to adjourn that hearing to a day or two later before a youth court judge, because it seems to me that if we do have a hearing, it's kind of hollow and a waste of time, in that the matter will be heard as a matter de novo automatically if a JP makes the decision on either side's request. So you'll note from 8.2 that if you do have a young offender and you insist that he go before a justice for hearing forthwith on a weekend, and you do get a hearing and you're successful, then the prosecutor from the one side, or the reverse, the defense, can just simply serve a notice and say, I want a de novo hearing. No grounds have to be given. No basis has to be provided except it was heard by a justice of the peace. And that's enough grounds for a youth court judge to hear it all over again, same evidence, and make another decision, which is not a review. It's an original decision on the evidence. So from that point of view, I think it's highly undesirable to not only waste your time, but perhaps the court's time by having hearings in front of a JP unless there's really no other option available. So that's the drill that is followed when the offender attends in court and the application is heard before the court. Now, there are things in this act that are known only to God, I suppose, and they mainly have to do with the power of a youth court judge to release a young person to what is called a responsible person. And this is certainly inconsistent with the provisions of the criminal code and therefore requires a special section, and that special section is found in 7. I don't know why it wasn't in Section 8, it should have been, but it's in Section 7, subsection 4. And as mostly defense lawyers here, I'm sure you'll love this section, and I hate it, of course. But it's very strange indeed, where a youth court judge is satisfied that a responsible person who is not defined, and nobody knows who it may be, is willing and able to take care of the youth who has been arrested. So it only applies where there's an arrest. You can't start fooling around with other bail type of releases on this matter. Only if there's been an arrest and the young person's willing. You don't want to place him with an unwilling person. It's interesting that the person who takes the child on this section must undertake in writing, not the child, not the youth. It's the person who takes him must undertake to take care of him, and he may then be placed in the care of that person instead of being detained in custody. Now, I'll give you my two-bit interpretation of this, not having any cases or not having any decisions on it yet. It's merely my interpretation. But I would think that it will be read as a section that would follow a bail hearing upon a decision prima facie that he should be detained in custody. Because when you read the section, I think that's what it's talking about. A judge has heard the facts, he's heard the bail hearing, he has come to the conclusion that detention in custody is necessary under 457 in the public interest or because he's going to flee or whatever. And having made that decision, you then leap to your feet as a last gasp, hope to get him out, and say, but wait a minute, I've got a responsible person in the hallway, and bring in your responsible person. And it seems to me that that is possible, that the judge will say, right, I have decided to detain him. However, if you can convince me that this person falls within this section, is responsible, the youth wants to go with him, he is capable of taking care of the youth, then I'm going to release him to this responsible person. And the thing you will love about this section is there is no appeal from it at all that I can see unless the Crown wanted to move by way of mandamus. There is no provision that I can find in the sections, and as I've said, the Act is now codified, so if it isn't there, I don't think it exists. I don't think this could be appealed except by mandamus. And the reason I say that is because the only person who has jurisdiction to make this decision is a youth court judge. And on appeal, you're not before a youth court judge. So I don't think that discretionary decision could be dealt with otherwise by a prerogative writ. And you all know that we're not going to bring prerogative writs too often in matters of a discretionary nature because we're going to lose them. And so it's a section that I think gives you an opportunity where you have a serious crime and a youth likely to be held in jail to do everything in your power to find somebody who has a three-piece suit and has a job and who can speak reasonably well and who is prepared to come to court and undertake the care of the young person. The problems with the section would be, what if there's a breach? If the young person does not show up in court, if the young person flees, it seems to me there's nothing we can do about that as far as the young person is concerned, because he hasn't signed anything, he hasn't made any undertaking whatsoever, and he has said nothing except, I'm willing to go with this adult. So I don't think we can do anything except issue a warrant for his non-appearance in court. But as far as the breaching of the section, I don't think there's any remedy. As far as the adult is concerned, it's my view that the proper process, if there's a willful breach of this by way of signing for the youth and then immediately fleeing to Panama with him, that could only be dealt with, in my view, by contempt under the YOA. And the contempt powers under the YOA are as wide as a Superior Court judge has. And this must drive the Provincial Court Criminal Division crazy, because they've got much wider powers in the youth court for contempt out of the face of the court than a Provincial Court judge Criminal Division would have. So I would move as a prosecutor, if there was a willful breach of this, to cite the party who had undertaken to take care of him, to produce him to court and so forth, and sign that for a contempt and have him ordered before the court and dealt with accordingly as the judge saw fit. But in any event, that's a sort of a section with no procedure attached to it. I shouldn't be telling you all these things that I fear as a Crown, because I'm sure you'll all do them now, but the fear I have is that there's nothing that says it has to be part of a formal court process. There's nothing that really says that a defense counsel can't show up ex parte and say, I've got a responsible person here, Your Honor, I'd like to see you in your chambers, and have him released. It doesn't say it has to be part of the bail hearing. I hope that the judges will see fit to interpret it as something which at least requires notice to the Crown as basic fairness, but who knows? It doesn't say anything about the procedure by which this is to be done. It merely says instead of detaining him in custody, a youth court judge may release him, period. I think that will be interpreted as part of the bail hearing in formal open court. Now, I've been asked to comment on any other little things that may come to light in this area. I think it's important when you remember that the Criminal Code summary conviction procedure applies, that the reverse onus provisions of the Criminal Code now clearly apply, unlike under the JDA where there was confusion about whether it was a summary or an indictable offense. It now makes it very clear that distinction does exist between indictable and summary, and that means that if you have a break and enter, release on bail, he commits another break and enter, the Crown will immediately dredge up the reverse onus provisions that you're all familiar with in the Criminal Code that say the onus is on you to get out now, your second crack at an indictable offense, or the other provisions that apply by way of reverse onus. And so you can be expecting to face those kinds of arguments on bail hearings if you've got a young offender who commits multiple indictable offenses, one after the other, that he's going to have to show cause himself for his release. You can also expect 458 to be thrown at you by the prosecution to cancel outstanding bails upon the subsequent commission of another offense. So you've probably been faced with that in criminal court, unless the Crown's been asleep, and I'm sure that doesn't happen in Toronto, but it does in